Hi, I'm Anthony Alder from Alder IP and welcome to another episode of IP. Today we're talking about a really interesting topic about AI systems actually inventing patents. Now it sounds fairly science fiction-y, but in Australia we've actually, well not granted, but the federal court has actually approved for an AI system to be officially awarded a patent. It hasn't gone through examination yet, but it has made the formalities checks which IP Australia rejected it on initially. The AI system is called DABUS, and it was invented by a Dr. Thaler. DABUS is actually, it is an AI system, but it is a fairly limited AI system. It has been acting in accordance with parameters, and it did invent two inventions which are subject to a patent. You can actually look the patent number up. It's 2019-363177. And the invention actually relates to two things. It relates to a almost Tupperware container sort of invention for food storage, which has a fractal outside. And the other one is an emergency flare beacon to alert people if you're in trouble. The invention relates to the shape of the wall. It's very unusual. It's fractal shaped. I think it's probably completely impractical, but that's for the invention. The other thing is also the flare. The flare has an encoded flare message in an LED system where it basically alerts people, and it has a higher probability of alerting people to it or drawing attention to it based on what the AI thought. So basically, the problem with this and is that the court actually looked at whether the AI system could be regarded as being an inventor in Australia. Now, under the Australian legislation, which is different to the rest of the world, an inventor is not defined by the Act. So an inventor, the court said, surprisingly, doesn't have to be a person. So an AI would satisfy that requirement. The problem is when you start going down to this level, you start getting into, well, Dr. Thaler filed the invention in his own name, and that's great, but how did he get the assignment? How did he get the intellectual property? Because normally with a real inventor, you would ask them to sign over their rights, they sign an agreement, they move their rights over to the company. If they're an employee, that they sign their rights over automatically to the company. But for an AI system, it's just a piece of property. It can't sign documents, you can't interrogate it, you can't ask it, why did it assign this? It hasn't been rewarded. In fact, it's actually acting as a slave in the whole relationship. If you go that step further, in actual fact, it's actually illegal to act with a person in a slave relationship. So therefore, how can possibly Dr. Thaler own this invention? Because whilst it was invented by an inventor, the problem is the assignment's faulty. The other problem you have with it is also obviousness. Patents are required to be inventive. Now, the problem is that computers at this stage aren't inventive. They can't invent something new from something. They can make probability decisions. So a learning engine is pretty much a way of giving the illusion that the computer is making something up. And it's not really making something up. What's actually happening is that it's making a decision based on weighted probabilities, and the probabilities are moving dependent on where the actual information is coming from. So different inputs give different weighting to different solutions. It doesn't actually invent anything. So the output that's produced by the computer, by the DABUS system, is really just invented by Dr. Thaler, because he's the one who told the computer system how to operate. You get into this sort of situation where if a computer actually invented this, it would be obvious because anyone given those set of instructions would have invented the same thing, because a computer is non-inventive. The last point is whether there's been an act of fraud or whether the patent office has been misled by Dr. Thaler in the first place. And so you really have to think about, well, is there an element of misleading, because he hasn't signed those forms that are necessary for getting a patent. In the US, his US patent was rejected because he couldn't sign what's called the IDS, which is the Information Disclosure Statement, because the computer couldn't sign it, because it couldn't tell anyone what the prior art was, because it has no idea, it has no self-awareness. And even the judge in the case said that his job wasn't to work out whether the computer was self-aware or not. His job was just to see whether it fell within the classification of being an inventor under the Australian law. And clearly the judge went out on a limb and said yes. It'd be interesting to see what happens with this case when it goes through the Patent Office, and I'll wait with bated breath to see what the IP Australia has to do with it when it goes through examination, because I expect more objections then. It's a really interesting space, and look, if you have any further questions about AI systems or about inventorship, please contact us on the links below. My name's Anthony Alder, and thanks for listening.